I've texted Ship. Hopefully, he's going to be joining us here. Just getting everything set up. Had to move to a different room, but it hasn't kicked me out yet tonight. So, woohoo! We're ahead.
That that's good.
Yeah.
Uh, uh, Ship posted that he's delayed. He may be a little late.
Okay.
He didn't say how late.
How late?
Right.
All right. Where did he on his timeline?
On the group, the small group
Oh,
timeline. Yeah,
you mean on our?
ours.
Mm, oh, late to the party. Oh, okay. Right. And I did want him to talk to the um the question about the National Guard issue, which is kind of on hold, but he understands the procedural moves there better than we do.
Yeah,
He's better than I do. So,
and me. I've, I think we're just waiting. We're waiting for the Ninth Circuit to. I mean, the Ninth Circuit en banc decision.
right, but there's been some interesting little moves about how that happened because of these two stupid TROs, that one right on top of the other, right?
Yeah, but they the panel stayed the TROs. Then the applicants, the petitioners for the TROs, uh, sought en banc review. That would be a review by the entire court,
Right.
and um, and that put the whole thing in abeyance with the TROs still effective. And at that point, I get lost as to where, as to
But the
where they
procedures
stayed
are
at.
right.
Yeah.
Yeah. Well, Ship is joined up. Let me send him the co-host. That's why I wanted him to explain it because
Mm.
it seemed like he understood the technicalities of the moves that were made there, and I was finding it a little hard to follow. So Ship, if you're listening, and I can see that you are, I just sent you the co-host, so maybe you can explain this machinations on the National Guard cases. Now, big picture, since we talked last, there's been no definitive ruling. Um, and so, in that sense, nothing has changed. But the procedure is a little bit interesting. So we'll see if Ship can explain it to us. The other thing that we're still waiting on, as of tonight, the Supreme Court has not ruled yet. There you are, Ship. Can you hear us? Oh, Ken, can you hear him?
No.
How about
No.
now? How about now?
Oh, yes, we
Yes.
hear you now.
Yes.
Okay.
Yeah.
Um, Go
So
ahead.
so what happened is you had the Oregon case came out Monday, I think. Monday or Tuesday. I don't have the dates in front of me. It came out on the 20th, which I think was Monday. Um, and in that case, you had three opinions written. You had the majority per curiam opinion, which was 2-1, which was pretty much straight down the middle and said we have to follow the earlier panel's Newsom decision, even though, well, they just, the per curiam opinion said that. And then, had some criticisms of Judge Immergut in Oregon for narrowing the time focus, um, and and then also, faulted Judge Immergut in Oregon for not being sufficiently deferential to the facts as found by the president. She simply, in some instances, disagreed
Mm,
based upon the presentation of affidavits by Oregon and Portland and said, I believe them more than I believe the president. So she just substituted her view of the facts for what the president's or the administration's representation of the facts to be. So then there was Judge Nelson wrote a concurrence to the per curiam opinion. And basically he said that, in his view, the Newsom court, which had been, a couple of months earlier dealing with a California case, the Newsom court got some things wrong. And but because it was a panel that had published an opinion prior to the Oregon case, the Oregon panel was bound by it. Now, the rule on that is a little bit up in the air, since this was a emergency stay, and then Judge Graber filed a dissent in the Oregon case, essentially lining her views up with Judge Immergut, the district judge, and criticizing. She also disagreed with the Newsom case, which was the first one. Now, I did a couple of 2 or 3 articles on that this week, and one of the points I made on the Newsom case, you go back to the Newsom case. Gavin Newsom files against the administration over the decision to federalize the California National Guard and deploy 4,000 National Guard troops into Southern California to help ICE. And sort of the difference in the circumstances were that all of that kind of happened in a very short period of time.
Right.
From like late May to the first week of June, every day there were running battles in lots of different places in Southern California, very much bigger geographic area than what was involved in Portland. I mean, you had from inner city Los Angeles, downtown Los Angeles, all the way out to Camarillo, which is 40 miles up the coast of Southern California, into a lot of more rural farmland areas where they were went out after farm workers and other workers in similar fields. And you had freeways being shut down and CHP cars having cinder blocks on them and all kinds of stuff in a very short period of time. Really a kind of an uncontested emergency situation. And
what is that noise?
That's a dog outside and a bird.
No,
going back inside.
Not the dog. I recognize the noise of a dog.
Yeah, it's a bird up in the tree above me.
Oh, it's a bird. Okay.
Yeah, I'm in a forest environment.
Okay.
That.
True. Okay.
So the Newsom case gets filed, and from the day it's filed, Judge Breyer, who heard the Newsom case in the district court, I think from start to finish, he spent 72 hours.
Right.
And then the government filed a notice of appeal the same night as Judge Breyer's TRO. And from the notice of appeal until the Ninth Circuit's opinion was 7 days.
Right.
So you've got everything happening in a 10-day time period about events that are all sort of unfolding at the time this is all happening. So some of the criticism that has been leveled at that first Newsom opinion has been that, it happened so fast, there were errors, the factual analysis wasn't necessarily complete. There were errors in some of the legal analysis. There was one particular Supreme Court case that was miscited in kind of a way that makes you think it was probably a law clerk that did it, and then none of the judges looked at the original site to figure it out.
Well, because they were doing it all in a hurry up. That happens sometimes.
Exactly. Yeah, absolutely. They're trying to get a decision out because Judge Breyer had, put the National Guard on the bench, and the administration had ongoing operations and it wanted them. So the Ninth Circuit acted with great dispatch. Not necessarily the wrong thing to do, but it has its risks.
Right.
So the Oregon case, though, happens now. Judge Immergut acted very quickly too. I think that case actually was initially assigned to a different judge. The different judge, I can't remember his name, is married to a congressperson, and the congressperson had publicly criticized the Trump administration's use of the National Guard in California. So the Trump administration, suggested that particular judge needed to recuse himself, and he didn't think it was necessary, but he did. And it gets assigned to Judge Immergut, I think this was so funny. It got assigned to her on the 2nd of October. The previous judge had already set a TRO hearing for the 3rd, but suggested, that if she needed to move it back, that it should be moved back. She went ahead and conducted the hearing on the 3rd and issued TROs on the 4th and the 5th.
Right. So that was fast too. Yeah.
Yeah, 48 hours, at least on her watch. And then that goes up to the Ninth Circuit, And now the briefing in the Ninth Circuit took place over, I think, just 4 days. So the briefing was very fast.
And
Um,
just on her first TRO.
on her first TRO. Well, they never appealed her second TRO. She filed two TROs. The first one, because the complaint itself only dealt with the federalization of the Oregon National Guard and the deployment of the Oregon National Guard, was the only relief asked for. When she filed a TRO, she blocked the federalization of the Oregon National Guard and deployment of the Oregon National Guard. Well, that was on a Saturday. So the Trump administration dispatched already federalized California National Guard up to Oregon. And then so on Sunday, the 5th of October, she issued a second TRO blocking the deployment of any federalized National Guard into Portland. So the government appealed the first one, but didn't appeal the second one. And it took about a week before there was an oral argument. And then the Ninth Circuit, the Oregon panel, so the second, different judges than the Newsom panel, just the way it works. They've got a merits, or they got a motions panel that was different on the TRO. And that panel, the Oregon panel, issued three opinions, which is what we started talking about. The 2-1 per curiam, which struck down the TRO. Then Judge Nelson's concurrence, where he expressed his view that some of the Newsom findings were wrong, needed to be revisited, but only an en banc court can revisit a panel decision of a different panel. And that's maybe that's a rule that people don't really appreciate and understand. Once,
Right.
and this becomes a real issue in the Ninth Circuit, where you've got 29 judges spread out over 11 different states.
Right. We wouldn't have nearly as much trouble with this on the East Coast, I don't think.
But once a 3-judge panel publishes an opinion that makes certain legal findings, all other later panels in the Ninth Circuit are bound by that until an en banc court changes it, meaning a panel of 11 judges. And the en banc courts are very rare. So the 3-judge panel decisions tend to stand up, even if other judges disagree with them. They're bound to follow them by the rules of the Ninth Circuit. So that's why Judge Nelson, even though he voted to overturn the TRO, he still wrote separately to say that he had problems with the earlier Newsom decision. He thought there were parts of it that were wrongly decided and should be revisited. So the very next day, you had, or maybe it was that night, it might have been later that night, the Ninth Circuit released finally, after 10 weeks, the order on, actually it was the next day, it was Tuesday, because the oral argument, this is just, it's great, the oral argument in the Newsom, okay, now remember the first Newsom decision of the Ninth Circuit was on the emergency motion to stay. The second oral argument in the Ninth Circuit was on the actual merits, the whether or not Judge Breyer got his decision right or wrong.
Right.
And the
because he kept
panel,
going with his case after they struck down his TRO. He kept going. Right. Yeah.
He kept going, and actually had a bench trial and issued findings against the government on the Posse Comitatus Act. Now that's the second appeal. There's actually two merits appeals. The first merits appeal is on his TRO, yep, and the second merits appeal is on his findings regarding the Posse Comitatus Act, which had not been part of the TRO. The California did not raise it as grounds for its TRO. So the easiest way to understand that for anybody who's interested in listening is the first TRO was about activating the National Guard. The second finding under Posse Comitatus was how the National Guard was actually used, because Posse Comitatus says that you can't use active duty military to enforce the law or for civilian law enforcement purposes. And so the Judge Breyer's trial and his judgment against the Trump administration on Posse Comitatus had to do with what the California National Guard did after his TRO, preventing them from doing anything, was overturned.
Right.
So you had the argument on that the same day the Oregon opinion comes down. Then the next day, You have the en banc vote denying rehearing of the first Newsom panel decision from back in June, the one that they produced after just 7 days. And there were 7. So in the Ninth Circuit, you have 29 full-time active judges. To get en banc reconsideration, you need a vote of the majority of the full-time active judges. So it takes 15 yes votes. Now, this is not done in the way you might expect, where every judge is expected to vote yes or no, and you have an announced outcome. The way the court does it is there's just either 15 yes votes or there's not 15 yes votes. You might only have 10 votes, and all 10 might be yes, but that's not 15. And the other judges don't do anything. And by not doing anything, they're effectively a no. But the only thing the court announces is whether or not a majority of judges have voted to reconsider, or a majority of judges have not voted to reconsider. So what happened was the order comes out on Tuesday saying a majority of the judges have not voted to reconsider. So then Judge Berzon, who's a Clinton appointee in his senior status, she writes a dissenting statement that is joined by, what was it? Joined by 7 active judges and 4, so 11 total judges, but only 7 full-time judges. Senior judges do not get to vote on en banc reconsideration. Only the active full-time judges vote on en banc reconsideration. Now, the Ninth Circuit has 29 full-time active judges and 23 current senior judges. So they got a huge cast of characters.
50 judges, basically.
Yeah. So, but only the full-time actives get to vote, but the senior judges can write views on the outcome of the vote. So Judge Berzon wrote a 38-page dissenting statement. She didn't get to vote, but she
had
wanted
stuff to say, so she
yeah,
decided
so
to
she
say
said it. Now, one of the judges that and this is so another interesting thing about this vote is that it was sua sponte, meaning most of the time, in almost every instance, when there is en banc reconsideration, it's because one of the parties asked for it, and that a vote was called for, and then the vote is 15 judges say yes. But you can have what's called sua sponte call for an en banc vote, which is just one of the judges who sees the outcome, doesn't like it, calls for an en banc vote. Well, that's what happened for Newsom 1, is one judge, sua sponte, called for an en banc vote. They don't identify who it is. But with Judge Berzon's 38-page statement, one of the full-time active judges that signed it was Judge Ronald Gould. Now, this is another Clinton appointee who turns 80 years old this year. So he's full-time. He's been around for a while. And Judge Berzon is a Clinton appointee. So they've been on this court together for 30 years. Judge Gould filed a 3-page dissent from the denial, which basically said, I agree with everything Judge Berzon says and a little bit more, and that's about it. But as a full-time active judge, he can call for a sua sponte vote. So I suspect it was him that did it, and I suspect he may have done it because she asked him to.
Yeah.
She couldn't. She had 35 pages of reasons, or 38 pages of reasons for why she thought there should be one. He wrote 3 pages, and then somebody called for the vote. So my guess is it was him.
Right.
So you have now what? In some ways, I have a suspicion, and you let me know if you agree. They knew that the judges that did not vote yes for this original Newsom vote, or this original Newsom panel that was put together in 7 days, in quite a hurried fashion, which all the judges are sympathetic to that, because they're all put in that position from time to time.
Right.
And they probably all have opinions that they wrote in haste that they regretted later on, or they're, unhappy with mistakes that were made. And that's not a question of partiality or partisanship or bias. It just happens to all of them.
Right.
So they knew this Oregon case was coming.
Mm-hmm.
And the Oregon case was not put together on the same timeline. The Oregon case did not arise out of events over just a small number of days in California. The Oregon case is one that's built on like 4 months of conduct in Portland.
Mm-hmm.
The Portland events are much more located in a small, compact area.
Mm-hmm.
And in some respects, the facts in the Oregon case don't support the administration's judgments to the same degree that the facts did in California, where you had entire neighborhoods taken over, freeways shut down, and all kinds of stuff.
Craziness. Yeah.
Right. And Oregon, I think there's a sentiment sometimes, collegiality among judges, and you know this, and you can speak to it if you want, and King knows it. You know, partisanship to some degree is set aside by the collegiality of the court. It's a small club that they're all
right.
And they don't throw hammers at each other because
Most
they
of
all
the
have
time.
to sit.
Right.
Yeah, they all have to sit in the lunchrooms and eat dinner together for, or lunches together for months and years. They're going to be trapped in that same little box, hearing cases over and over and over, week after week, month after month. So I think there might have been some sentiment. It's like, let's not visit too harshly the original Newsom panel who tried to, who got thrown into the breach. Judges don't volunteer. Their name just gets picked out of the hat. And we're put in a tough situation on an issue that had zero or almost zero established precedent. You got the 1827 Martin versus Mott case that everybody has to go back to.
So you have something that's difficult. There's not much law to rely on, and you're doing it in a hurry. And so, surprise, surprise, you didn't get a great result in terms of the work product.
Yeah, so let's not bang on that panel with an en banc court with lots of time and lots of law clerks.
Right.
Let's wait for the Oregon case. So the Oregon case comes out. En banc is denied as to the Newsom case. But then the same day the Oregon case comes out, within 2 hours, you have another sua sponte call for an en banc vote. And my guess is it's Judge Gould again.
Again, yeah.
And so normally, and Judge Sidney Austin, Sidney Thomas, who is another senior status judge, but he occupies the role of the en banc coordinator. So you can't have the circuit the chief judge do it because he's got too much other stuff to do. The circuit's so damn big. So a senior judge takes on the role of being the en banc coordinator, sort of managing all the en banc applications. And so Judge Thomas issues an order after the sua sponte call for an en banc review pursuant to the rules of the court. Judge Thomas gives the two sides only 24 hours to file a responsive brief to the call for an en banc review. And I didn't read either one very closely, but both parties complied. By midnight the next day, they filed their response. Now,
and this is happening since we talked last.
Correct. This is all last week.
Yeah.
So under the Ninth Circuit rules, and I had to go back and reread them. It's been a while since I looked at them. That triggers a 21-day period, so 3 weeks, during which all the judges, the 29 judges, or even the senior status judges, can circulate memoranda back and forth amongst themselves as to why or why not a particular case is worthy of en banc review.
Oh, did we lose you? We always lose him right when he's making a point. King, can you hear him?
No.
Oop. And now it looks like he's dropped off. I think he's having a technical problem. All right, Ship, I see you still there. I'm going to send you the co-host again. Ron is laughing at us. Yes, Ron, we're struggling through our spaces again tonight. Do you want to talk? DM me if you want to talk, if you want to join in. So what Ship is talking about.
And I'm not in a bad spot.
Okay.
So I'm not sure what happened there.
All right. The gremlins are at us again.
Right. So you get this 21-day period during which all the judges can exchange memoranda, and there might only be 3 or 4 judges that even care. They write all the memoranda.
Right.
But and so there's supposed to be this 21-day period, and then there's a vote. Well, after 2 days, Judge Thomas issues an order that says that with the agreement of the panel, or without objection by the panel, meaning the Oregon panel, the panel's opinion is stayed until Tuesday of next week at 5 p.m.
Right. So this coming Tuesday in 2 days.
2 days from now, and that the court expects to complete its en banc decision by Monday. Now,
The vote or the decision?
the vote.
Right.
Vote. So now the 21-day rule that's just for the benefit of the judges. They can all set it aside if they want.
Yeah.
They don't have to. There's no reason they must wait 21 days. So I suspect that and as Judge Nelson made clear with his concurrence, even though he thought Newsom was correctly decided, he had problems with the Newsom analysis that he would change. So there's, from all sides, the Newsom analysis was being challenged. And to the extent it was the Oregon court felt bound by the Newsom analysis, it's bound up in the Oregon decision.
Right.
So
in the California decision. So the problem's carrying over. Yeah.
Yeah. So it's not just that, one side, it's not just that the losing side in Newsom and Oregon wants to revisit the issue. There may be judges that agree with the outcome in Newsom and Oregon who want to revisit Newsom's analysis and revise it in some fashion. So it's hard to know exactly where this will go, but it sure seems like the signal to Judge Thomas was there's 15 votes. We don't have to wait 21 days. Let's just do it.
Let's just do it. So the upshot as a practical matter is that the Oregon panel had struck down Immigrant's TRO, and now that's on the striking down is on hold.
Well, and there's another whole interesting, while this was all unfolding, during the week, I think on Wednesday, there was a hearing before Judge Immigrant on the second TRO.
Right.
Because the government had gone back and filed a motion asking her to vacate the second TRO because she said she didn't issue a written opinion for the second one. In open court, or actually telephonic conference on that Sunday, October 5th, she basically said, bringing in the California National Guard is just a violation of my order. My order was clear that the exigency had not been met to authorize any National Guard. So I'm going to extend, or I'm going to issue a second TRO making clear that, the government, the president's use of 12406 is not justified, and it doesn't matter what National Guard. So she had said that, on the same analysis as my first TRO, I'm extending on the second TRO. The Ninth Circuit in the panel decision said that essentially the government said it didn't appeal the second one because it didn't see a need to, that because she had said the rationale was the same, if the rationale on the first falls, the rationale for the second must fall as well. The Ninth Circuit seemed to agree with that and said the two rose and fall together, even though the second TRO was not before them, and the second TRO applied to different entity. It applied to the California National Guard, not the Oregon National Guard. So there was this, and her trial, the trial on the merits that she's going to conduct is next Wednesday.
Right.
It's like 3 days from now.
Because all of this is just trying to get the appeals court to issue a stay or not on a TRO that was issued now, how long ago? 10 days? 2 weeks?
October 4th and 5th. No, her TRO's, so today's the 26th. So 2 weekends ago.
2 weeks ago. Right.
And she's going to have a trial inside 30 days on the merits.
Right.
And Judge Breyer did the same thing. Like he was 60 days start to finish, and he had 3 weeks before he wrote his posse comitatus opinion. Now, some of this, I think, I started to write about this. Some of this, I think, is an effort by these district judges to get their findings on the record, get their factual findings on the record, so they think they benefit from the clearly erroneous standard for factual findings.
Right.
Making it harder to revisit their decisions at the appellate level.
So let's pause there and explain this to people. So when you appeal something that you've lost, the trial judge, the district judge has, made rulings of law, has found certain facts, and then applied the law as that judge has decided it should be to those facts to reach ultimate conclusions. Okay. You can appeal any or all of that, the conclusion, the factual findings, and the legal rulings. But the Court of Appeals is going to apply different standards to those. So if it's a question of law, they're going to review that, what lawyers call de novo, meaning they can figure out the law just as well as the district court judge. And so they're just going to decide on their own what is the correct interpretation of the law. And whichever side makes the best argument in the Court of Appeals wins that argument. So they start from the beginning and figure it out. On the factual findings, because the appellate judges, they didn't hear the testimony, they didn't see the people testify, they haven't read every single document like the district court judge did, blah, blah, blah. They defer to the lower court by saying, well, we're not going to set aside any factual findings that the district court made unless they're clearly erroneous, like the record just doesn't support them, basically. And then on the ultimate conclusion, mixed questions of law and fact, it's kind of somewhere in between. And sometimes the statute will say what standard the judge is to use, the appellate courts are to use. So what Ship is saying is that these district court judges are in a hurry to put their factual findings on the record and put their spin on those, because that's where the appellate court is least likely to overrule them based on the standard that the Court of Appeals is going to apply. And so you saw did you see these twitwits, lawyers, but lefty lawyers on Twitter saying, there's nothing to do here. The district court's findings are not clearly erroneous, and so there's nothing to appeal.
Yeah, it's like that's why I made fun of the Seventh Circuit's view of Judge Perry in Chicago,
Right.
which was not wrong enough.
Right, exactly.
Wrong,
So
but not too wrong.
not so wrong, right. So, okay. So yeah, I agree with you that this is part of what's going on with it as a tactical matter, is the district courts want to try to, make their factual findings robust, trying to keep the appellate courts from overruling them.
Right.
We'll see.
So that vote, the en banc vote, should maybe happen. Now, there's no, en banc.
Ah, lost you again, Ship. Yep. He says he's declined to co-host. He's not even doing that. It's being being done to him. Well, he's disappeared. Now watch, he'll pop back up here in a minute. So frustrating. Here he is. All right, I'm sending you another co-host invite again. King, are you following all that? Have you got any commentary on this?
Yeah, might touch on some new developments on the ground in Portland. I see news reports that the police in Portland have significantly increased the degree of aggressiveness they're using against protesters around the ICE facility. They're actually cleaning the streets up as we speak.
So if
Yeah.
I can poke in before
Yeah.
Ship
Hey,
gets his
Ron.
act back together. Hi guys. But you brought up a very important point, of course, which is that these judges, these really cynical operators, who they want to make their best possible record before this all gets reviewed. But the irony here is that the fight. You mentioned earlier, Leslie, or maybe it was Ship. You two are the same to me, interchangeable.
If we look so
Both
much alike.
sides, both sides uh, want would like to see um, would like to see the original decision tweaked,
Right.
which is why it probably won't be, uh, unless and until it gets to the Supreme Court. The issue for the pro government side, by which I mean the United States government, not the insurrectionary government, is that there is no, it won't, factual record is irrelevant. Factual findings are irrelevant. You're not a super executive judiciary. The
Well,
only
this
court,
is the U.S. government's first argument is that there's no review.
there's no review, and as you know, in the Newsom case, the Ninth Circuit probably, as I understand, you guys may have already gone over this territory, but what insightful people have said, maybe it was even you, is that they probably got the result they did by the pro-Trump on the panel, at least the pro-government, the pro-federal government judge saying, "I'm willing to join in a decision that reserves for the judiciary the power." People keep misusing right to
Mm,
refer to what different branches of government can and can't do. It really should be power.
right.
People have rights, um, but we should we don't want to absolutely say there's zero reviewability whatsoever. So they say, yeah, if the president became a was a, if the president were a madman and you know went like King George III, not during the Revolution, but 20 years later when he was absolutely not lucid. Well, then that would be an appropriate time for us to step in, which is, like that's a reasonable bar stool opinion to have. But frankly, it's not in the Constitution. The Constitution. So what these guys on the Ninth Circuit, and it's typical that you, not typical of you, but typical of Breyer to be someone that you would judge Breyer, who is an incredibly dishonest judge, really just a cynical operator. Um, he's appropriate to be invoked here because these guys are in such a bubble. They obviously don't realize what everyone else in the world realizes, which is that they're making it so much worse for themselves by sticking with these impassioned pleas. These and the same thing goes with Justice Jackson. These melodramatic, uh, I am Spartacus stands that they're taking in judicial opinions. They're just setting themselves up for major, major bench slaps in ways that probably would not have been necessary. Because if this indeed goes past the Ninth Circuit, it's going to go to the Supreme Court, which may very well say this is completely non-discretionary.
Yeah, I
They,
don't
I
agree
mean,
with that, Ron. We
that they might say that, or
Oh, that
that is a
that's the right
risk.
answer. On this statute, I think there is some judicial review. We tossed this idea about
Hmm.
previously. This statute sets up factual predicates that once they're established, then the president can act. The other statutes, the Insurrection Act statute, doesn't. It vests discretion in the president to act when he considers certain things to have happened.
Yeah,
Right?
yes,
Yeah.
I understand that. I understand the
Yeah.
distinction. All having said that, when Immergut says, "Well, it's not as if the president, like we really don't have a record sufficient for us to say the
Mhm.
president absolutely positively can't use the regular federal forces." Like that's truly preposterous.
Oh
And
yeah, and we've discussed that too. We agree with you about
oh,
that.
I'm
Yeah,
sure you have.
yeah.
And I'm not actually even necessarily
Now I can't hear Ron. What?
this.
There we go.
Yeah, I'm not saying I'm not also not necessarily saying right or wrong on this, but I am
Mm.
saying that they've got the
Oh, Ron, we're losing you. Ron, are you in the car? Well, oh no, it's yeah. Ship is back. So Ship, you want to pick up that? I'll see if I can get Ron back in as a speaker. It dumped him out this time.
Yeah, so I'm not sure. I want to let Ron, see if Ron stop for himself, but I'll just go for a second on how what the Ninth Circuit will do now.
Right.
I did write about this, but not everybody obviously reads that. So the way the
They
Ninth Circuit,
should. You should be reading Ship's Substack if you're not.
yeah, the way the Ninth Circuit's en banc, and I think every other court, I think it's every other circuit except the Ninth en banc. En banc means the entire court, every judge.
Right.
And in most circuits, that's 8, 9, 10, 11, 12, 13 judges.
Right.
But with 29 judges, the Ninth Circuit realized long ago we can't have 29 votes in a case. We can't have 29 judges because previously they would all meet in a courtroom together.
Yeah, right.
Now they can do it electronically more than they were willing to do so historically. And the Ninth Circuit, the judges sit everywhere from Montana to Arizona to Hawaii to Alaska. So getting them all in one place for hearing was always problematic. So the Ninth Circuit sits in 11 judge panels en banc. So roughly 1/3 of the active judges will hear an en banc case, not the entire court. And the way that is selected is the presiding judge is part of every en banc court. Well, that currently is Judge Mary Murguia from Arizona. She's the current presiding judge. The other 10 judges are selected randomly from the remaining 28 judges on the court. Currently, Judge Murguia is an Obama appointee. So if you're just going to kind of evaluate them on partisanship lines, you would say that, okay, so the liberal progressives have, one member already. And this is not a subject where the administration is going to want her. Her sister, she's had to recuse a couple of times because her sister has been a member of the national leadership of the La Raza, I can't remember what the full name of it is, but it's a Hispanic rights organization that goes back 70 years in California, and she has been in the majority on several meaningful decisions on immigration issues, always siding with the immigrant. So she's something of an activist judge on this particular topic.
Am I right that the panel who are being reconsidered on, they don't have a right to sit on the en banc?
Correct.
Yeah.
They are eligible, but they have to be. They're just if they are drawn to the en banc, it's random selection, just like any of the other 28 judges. Now, the interesting thing, the one little twist is, while senior judges cannot vote for en banc reconsideration, nor are they allowed to serve on an en banc court unless the senior judge is part of the panel. So Judge Graber, who was part of the panel and was the dissenting vote, she can actually be part of the en banc case at her election, meaning she can elect to be available or eligible to be drawn. She's not entitled to be drawn, but she can also decline. So I expect she wrote a long dissent to the Oregon panel's decision. I expect she absolutely is going to want to be part of the eligible body of, so that would make 29 other judges available for the remaining 10 slots. Okay. Of those 29, 16 would be Democrat appointees and 13 would be Republican appointees, with 10 of the 13 being Trump appointees.
Okay.
President Trump appointed 10 members of the Ninth Circuit in 4 years, and everybody that bangs on and criticizes Mitch McConnell should tell him thank you, because he held all those slots open
for us. Right. Okay, so they will probably this week tell us that they're going to rehear that. And will we know who the en banc judges are?
Not until the hearing is set.
Okay.
Now, I expect that to be very quick. Because I suspect that the en banc court would love to. First of all, there's been so much briefing. You had a fully briefed district court case out where both sides in California were heard. You had that go up to a panel, be fully briefed in the Ninth Circuit. You have the Oregon case. Judge Emmeritt writes a long opinion, and then that's fully briefed by both sides twice. So there's no lack of. You had Judge Berzon's 38-page dissenting
Right. It's not
statement.
like we haven't killed a bunch of trees on this case.
Right, both sides of all these issues, including the Oregon case, which has 3 opinions, you know,
Right.
saying Newsom's wrong from 2 different directions, plus the per curiam saying we got to follow Newsom.
Right.
Um, so there's no shortage here. So I think that they will set the argument very quickly with the idea that they get a decision and opinion out very quickly and maybe beat SCOTUS.
All right, so that's where I wanted to go with this. So, when you were on one of your little inadvertent breaks here, I was going to tell the folks that the Supreme Court, as of tonight, let me check it here while we're talking, has still not ruled on the Seventh Circuit's case. And this is where the administration is seeking a stay from the Supreme Court on this same issue, but based on the case in Illinois, not Portland and not California. Um, and this is the one where the judge did her own investigation as part of determining whether the predicates were made. Oh my God. And so that is fully briefed for the stay application, but no ruling has been forthcoming now since the last reply, I think, was put in on the 21st. Yeah, 21st. And today is the 26th. So probably they have voted on that, right? And what we're waiting for is the writing of the opinions. Probably just playing the odds. Again, one of these long dissents by one of the liberal justices. Would you agree, you guys?
Probably, but I don't forget what the local law enforcement is doing in Portland.
Mm-hmm.
They are trying to upset the apple cart. They are they're trying to totally remove all possible predicate for bringing out the National
How
Guard.
do you think that will affect
And
the Supreme Court?
I, if a judge has a trial Wednesday and hears that evidence, and they bring photographs showing that the staged violent protesters are not there anymore, and they've been arrested by the police and run out of town. That I don't know. I honestly don't know.
Well, I
I
don't see
don't
how that
see.
would affect the Supreme Court's review of Illinois.
Um, but
Could affect
they
the Ninth Circuit's review of
it, it
Portland.
it 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 could affect their reasoning. They even with Illinois, they have to consider whether there is a threshold level of ability to or inability to enforce federal
Right.
law,
Well, John
and
Sauer's brief.
what kind of factual
Yeah.
finding must exist. A factual predicate must exist.
I got
And
I got 6 words for you, King.
what's that?
Capable of repetition yet evading review.
Yeah, right. Okay. So this is the theory that lawyers use to say some things that could get mooted out because the facts on the ground have changed. The judges normally will apply that rule. Facts on the ground changed, or the situation of the parties has changed and it's moot, then we don't have to decide anything. But there are some things that lawyers call this capable of repetition yet always evading review, meaning that, well, it can just come back and the parties are kind of engineering almost that the courts can't rule on it because we will just clean up our act and then there won't be anything for them to rule on. Ha ha. And the courts will sometimes say that certain things they're going to make this exception for because it's just going to come back again and everybody knows it. So, to put it in vernacular terms. So, I think it doesn't.
Sometimes they punt too.
Yeah,
Yeah,
sometimes they punt. But the facts, as described by the Solicitor General's brief to the Supreme Court about what's going on in Illinois, are horrifying, right? Cops being boxed in by cars, being forced out of their cars because their tires are being slashed. I mean, it's just revolting. So I can't see the Supreme saying, "Oh yeah, that's fine," because they're not doing it this week, right? So, but what about the interplay between the two courts? Do you think, Ship, that the California judges might wait to see what the Supremes are going to do?
Not if there's, it depends on the panel.
Mm-hmm.
But if that panel gets drawn, say, 7-3 progressive liberals,
Yeah.
I think they're going to want to try to beat the Supreme Court to the punch. And I'm a cynic.
Mm-hmm.
I'm a complete believer in gameplay.
Yeah.
And the Chief Justice has never seemed inclined to force those dissents to come out on a timely basis. He's held
Right.
rulings on TROs
Right.
while those 25, 30-page ridiculous dissents are being written. And I could see, Justice Sotomayor and Justice Jackson back behind closed doors saying, let's just not be in a big hurry to do this.
Right. Let's just take one more day to write this up. Well, it has kind of surprised me that there hasn't been a sense of urgency about this, except by the administration, of course. Um, but the situation is very fluid, and as King is pointing
I add
out,
something to them? Can I add something?
yeah, I was just about to say, and as you've been pointing out, the local police are sometimes changing their approach, right? So go ahead, King.
Don't forget, a TRO is limited in time.
Yeah.
And so, and when it expires, either the case goes away or they have a trial, evidentiary hearing, like they're about to have in Oregon on Wednesday.
Right. Do we know
So,
if when there is such a trial set in Chicago?
don't
I
know.
don't think I know the answer to that either. I'll have to look it up. Right. So, but I don't think Roberts is
Hold
going
on,
to let them go on
wait.
for 2 weeks. Yep.
Where they're at in Chicago
Yep.
is the TRO in Chicago expires, I think, on the 29th, and the judge has already set on the 26th or 26th, might be tomorrow or Tuesday, a status conference to extend the TRO
Right.
another 14 days while they finish discovery so that they can set a trial date.
Right.
So
Sauer will
that's
just file a notice with the Supreme Court saying, well, they extended it, because that's what she's going to do, that judge in Chicago.
Yeah.
Right. Yeah. I think we'll get a ruling from the Supreme Court tomorrow or the next day. What do you guys think?
I expect it, yes. If unless they want to punt,
Right.
they may want with these developments out west with quick trials.
Mm-hmm.
They may want to wait to see what kind of record is developed,
Mm-hmm.
so they can write with some, at least some intelligence regarding the facts on the ground.
Right.
How bad is it, and where do we draw the line?
Right. Chip, is this Illinois case the one that you said that the government kind of played thin on their facts?
Yeah, more so than Oregon. They did.
I think the punting era is over.
You do?
Yeah, I think, especially, I think that Roberts has
Mm.
reached the point where he sees
Yeah.
he's not going to get 8-1s.
Mm.
He's not going to get 7-2s.
Right.
He's going to have to make law based on 6-3s, and the soft 6 members see what's going on here. King, I tend to agree with Ship here, not only because of the capable of repetition issue, but because of the cynicism. The Supreme Court justices, especially conservatives on this particular court, are not dummies. They see what's going on, and as Ship
Yeah.
pointed out in an X post earlier today, they're going to the mere fact that they're able to turn it on and off like this means that there is in fact no real control
Right.
from the point of view of the federal government. It's incredibly cynical. They're really proceeding in bad faith. I think it might actually weaken their case. Although, frankly, it's you know, I, what do you do? Just continue to undermine civilization the way they have?
Yeah.
But I don't think, King, that the Supreme Court is waiting around for the opportunity to punt, because I think if we here in this space get the game, they get the game every bit as well. And not only has Roberts, concluded that 6-3 is going to be what he's going to have to take for these separation of powers decisions. He's a separation of powers man. These are the cases in which he is not going to say, "Hey, the referee shouldn't decide the outcome."
Right, I agree with that. He's
That-
less comfortable in sort of the more cultural cases. This has to do with the structure of the government, and he's more reliably on the right with that.
I agree with that 100% if this were an appeal and they're deciding
Mm-hmm.
the case on an appeal where
Mm-hmm.
they've developed record on the court below. But that's
Right.
not the
What does
case.
the statute mean? Well, you're
This
right.
is
It's not.
That's
It's
not the case. We're dealing with a short.
Stay of a stay of a stay of a stay.
yeah.
Correct.
I mean, even trying to explain it to lay people, their eyes glaze over with, we're getting
Well,
a
but can I?
stay on
But
an
Leslie,
opinion on a TRO. Yeah.
there is lurking below all these cases an opportunity for the majority to come out and say, time for a primer, district court judges, on, and they tried this, but it didn't
Mm-hmm.
take,
Yeah.
a primer on preliminary relief.
Yes. Especially against the
You
government. Mm-hmm.
don't get it, and especially against the government. You're missing the plot.
Right. So, switching to somebody else who's missing the plot, shall we talk for a minute about these state and local officials who seem to think that they can somehow direct local police officers to interfere with or even arrest federal immigration officials for carrying out the immigration laws? Like, I've been
Mind boggling.
horrified at this.
Mind boggling.
Yeah. King, Ship, you want to weigh in on that?
Uh,
Yeah, In re Nagel. If you can't
that
prosecute, if you can't prosecute a marshal
Yeah.
yeah,
who
they
shoots somebody, and the state of California wants to try him for murder.
Right.
He shoots somebody while he's protecting a Supreme Court justice back in 1849.
Yeah, I think so.
And the Supreme Court says, no, it's not a self-defense case. It's an immunity case.
Right.
He does not have to answer in the California courts for the performance of his official duties.
And all
You know,
these officials and cases that we learn. So, an arrest federal immigration officials for carrying out the immigration laws. Like, I've been
Mind boggling.
horrified at this.
Mind boggling.
Yeah. King, Ship, you want to weigh in on that?
uh,
yeah, In re Nagel. If you can't
that
prosecute, if you can't prosecute a marshal
Yeah.
yeah,
who
they
shoots somebody, and the state of California wants to try him for murder.
Right.
He shoots somebody while he's protecting a Supreme Court justice back in 1849.
Yeah, I think so.
And the Supreme Court says, no, it's not a self-defense case. It's an immunity case.
Right.
He does not have to answer in the California courts for the performance of his official duties.
And all
You know,
these officials and lawyers online, social media are saying, well, they can't just ignore state law. Well, yes, they
yes, they
can
can.
actually.
That's exactly
Yes,
the
they
point.
can.
Mind boggling.
It is
It's
that
mind boggling.
it's as if no one knows what happened at Fort Sumter.
Right. Or the civil
so
rights. We just missed all of that somehow, right? In
so
history class. Go ahead, King.
my question is, when will the first arrest of a state official happen?
Oh, my goodness. I
I
mean,
don't think it'll ever happen, because I think
no.
all the lawyers all of that is political theater.
Yes, right. Except for that gal out in California, where is she, in San Francisco, who was like the district attorney there, and she was going to impanel a group of her officers to review the tapes, a la what they did in January 6th, to try to identify these ICE officers so that they can arrest them later for using excessive force. And Oh my goodness. Did you guys see the letter Todd Blanche wrote to them?
I saw a lot of Todd Blanche wrote, yeah,
Yeah.
and
That yeah, and there was also a preservation letter that
Yeah.
was followed up. That's you know, there has been such a deterioration
Yeah.
in in basic civics understanding by these activist Democrats. Like they've gotten so used to laxity, and this goes back to the Trump administration as well, and frankly, really the 22 generation of Republicans who have let this slide in the state. It's with the states. It's unfortunately it's going to be a heavier lift to get things
Yes.
aligned properly the way they ought to be. And the irony here, the great irony, is that the Supreme Court is going to be relying on this incredible line of cases from the civil rights era,
Right.
and they should.
Right. I agree because the idea that state officials can interfere with federal function is that state officials even think they can say things like that to the public, which is dangerous to my mind because it might encourage people to take actions that will
Of
not
course,
work
it
out
does.
well for them.
100%.
Yeah, is just mind-boggling to me. I just am astonished at that. That some people don't know that civil lawyers say things like, "Well, it's only qualified immunity." Yeah, okay, no, it's supremacy clause immunity, dudes. Is right? You can't do anything about it. Now, I will say for clarity, a federal officer who violates federal or state law not during the performance of his duties, yeah, of course they can be arrested. You can be a federal officer and commit a DUI, right? Especially in your POV, your personal vehicle. But when a federal officer is engaged in the performance of their duties and they're not using excessive force, they just cannot be subjected to state court laws. And this is one of the oldest constitutional principles that you learn about in law school. It's one of the first cases that we learn. So it just staggers my imagination that they want to spout all of this nonsense off like it has no real world consequences, right? That's the thing that really bothers me. So, okay, let's shift course to the appointments issue for both Comey and Letitia James. So I finally read most of the pleading that you sent me from the California case. So to set the stage for people, so Ship, is it 4 U.S. attorneys now where this is being litigated?
I mean, I know of four. I
Yeah.
don't know that it's only
You
four,
don't
but
know of any
it's
others? I don't either. Okay, so the
Central District of
4.
California, District of Nevada, District of New Jersey, and now Halligan in the Eastern District of
Now
Virginia.
Virginia. Okay. Those are the only 4 I know about too. All right. So, and they're all at different stages of development, of course. Um, the California case is about the LA U.S. attorney. Is that right?
Yes.
Yes. Okay. And that's in the Central District of California, right?
Yes.
Yes. Okay. So in that case, um, the the briefing is up to the level of the district court, but the district court hasn't ruled on it yet. Is that right?
Yes.
Okay. In New Jersey and in Nevada, the district courts have ruled on it, and we're up in both courts of appeals, I think.
I know for
Um,
sure the Third Circuit because it's already been briefed.
yeah, and
And that's
argued,
the New
right?
Jersey one. I don't know yet about. I'm not sure what the status of the Nevada one is in the Ninth Circuit. I haven't looked.
Yeah, it's in the Court of Appeals, but I don't know if it's fully briefed. And the New Jersey one, the Third Circuit held their argument. Didn't you listen to part of that?
I did not.
Ah, okay. All right. So now in Virginia, we're nowhere near that far ahead along the path. So both James Comey and Letitia James have, that's something I hadn't thought of just now. It's like James Comey, Letitia James. Okay. Um, they are filing motions. They both have filed motions. The government hasn't responded to either one of them yet. in their cases. Now, his case is in Alexandria, her case is in Norfolk. And so, because this issue involves the propriety of whether the U.S. attorney has been properly put into her post, what the judges do is those judges themselves don't rule on that motion. There is an out of district judge who is appointed for that purpose to rule on this one motion. And so in Comey's case, the judge asked for an out of district judge to be appointed. And I think that's done by the chief judge of the circuit. I think the circuit controls this. And so a judge was duly appointed, Judge Curry, who's from South Carolina and is a senior judge there. Um, and then, because James Comey's lawyers filed those motions for him earlier this month, he filed a notice that he was going to do so on the 14th, and then he filed his motion on the 20th. And then Letitia James, because her case is about 2 weeks behind his, she filed a motion, the notice on the 23rd that she was going to file that motion, which is kind of the procedural device that kicks off this out of district judge procedure. And then on the 24th, she filed the motion actually. And because Judge Curry had already been appointed in Comey's case to hear this motion, then I think her lawyers actually asked for, and the judge down in Norfolk agreed to transfer her motion also to Judge Curry, who then issued orders in both those cases, setting a briefing schedule for that and set the same schedule. So the government's response to the motion is due on November 3rd, and the defense lawyers' replies are due on November 10th, and then Judge Curry will hold a hearing. And I'll be interested to see where that hearing is exactly, or whether they're just going to do the whole thing by video conference on November 13th. And at which time, then after that, we'll get some kind of ruling. So, this is the first time I've seen of defendants across two different divisions within a district doing a consolidated procedure like this for any kind of motion. Have you guys ever seen that before?
I've seen it once or twice in my career where that's happened. Yes,
Right. It's very rare, don't you think?
yes.
But the internal operating procedures allow for it. In the other cases, it's like multiple defendants in the same district have joined together to challenge the appointment of the U.S. attorneys in New Jersey, Nevada, and California. But I don't know if they're in different districts or not. I guess I could look at that. But here in Virginia, they just happen to be in two different divisions, which are the subparts of the district. And so this judge from South Carolina will rule on that. And go ahead, King.
Yeah, there's a statute that applies when you have the same type the cases with identical issues in several districts, and
Ah,
you can consolidate them at least pre-trial in one court, and have all your pre-trial motions and discovery and whatnot happening in a single district. And then when that
mhm.
pretrial part is over, then they decide whether to
Yeah,
uh, maintain a consolidation for a trial or send them all back to where they came from. But within a single district, uh, there's no
yeah.
statute, but
Steve
the
says he
courts.
thinks that statute only applies to civil. He doesn't think it applies to the criminal, but we're not.
That is true. That is
Yeah,
true. It's
that
only a civil.
we'd have to look at that. But it's a good analogy. And here you have the wrinkle that they're already in the same district, right? They're just in different divisions, but we're using an out of district judge to do the ruling. So it's an interesting technical procedural thing. I don't know very much about Judge Curry. I will look up some information about this judge, and we can talk about that next time. Both of those defendants have filed motions also to dismiss based on vindictive and selective prosecution, and I don't propose to talk about those tonight. I want to wait until the government responds to those, and maybe even the replies, so we can see what all the arguments are before we talk about that. But they have both filed those. And then interestingly, Letitia James, but not Comey, have filed this motion that we've been seeing in these other cases recently asking the court to order the government to stop making outside of court statements about the case. So I will, next time we talk, I will have gone through all of her arguments for that. And the government has to reply to that on Tuesday, respond to that on Tuesday, and then the defense reply on that is due on Thursday. So we can talk about that next week because it'll be fully briefed. Okay, so their basic argument is that Harrigan is not properly appointed. And I finally have understood what the government's argument on this is. So, what I thought we might do tonight is talk about two issues, not the whole, because this, as we've talked about before many times, this argument, this issue raises so many sub issues that need to be decided. It is very complex. But I thought we would try to cover briefly two of them. The first is whether the statute allowing for the appointments is constitutional under the Appointments Clause. We're going to do this at a high level and at high speed. And then the second one is basically what is the government's argument under the statute for why they think the appointments are fine. So, so people understand the Appointments Clause in the Constitution requires or gives power to the president to make certain appointments, and it gives power to the Congress to specify how certain appointments are to be made. And it depends on what kind of officer the person is in the government. And there's different rules for principal officers and other rules for inferior officers. Everybody seems to agree that the U.S. attorneys are inferior officers, meaning that they can be appointed by the president, but they're not required by the Constitution to be appointed by the president. And so the Congress has passed several statutes that apply to this. And in some of those statutes, they give power to the president to appoint, some to the district court judges to appoint, and some to the attorney general to appoint. The U.S. attorney, and we're going to go over what those are in a minute. But I don't see any argument, do either of you, that the statutes that are passed by the Congress for this purpose, the U.S. attorneys, I don't see those as being unconstitutional. Do you guys?
Apart from the uh, subordinate, the
Inferior, yeah.
inferior. That's the word I'm looking for. Yeah. Inferior versus presidential appointee requiring uh, advice and consent by the Senate, the high level. Uh, I don't, and I thought it's a given that U.S. attorneys are inferior.
Right. I don't think there's any
It-
real argument about that.
other than that issue, I don't see the basis for saying it's unconstitutional.
Right, I agree. So I see a lot of people online saying, well, it's unconstitutional for the judges to appoint, because that's one of the statutes gives them sometimes the power to appoint. But I don't agree with that at all. I think that the Congress has the power to say how the U.S. attorney is to be appointed. Um, so I think the constitutional question is just off the table. There's really no issue there. The government does not seem to be arguing that there's a constitutional problem. And the defendants in their motions, they tend to mention the appointments clause, but more like in context or background. It's not like they seem to think it's a big issue either. So I think we can set that issue aside. Okay, and then what the Congress, as I said, has passed multiple statutes that say how U.S. attorneys are to be appointed. One of them is the Federal Vacancies Reform Act, which is in Title V. And this is the one that allows for the president to appoint a bunch of different kinds of officials, but with respect to the U.S. attorneys also. And this is the statute that allows the appointments for 210 days. And it's actually 300 days if the person is appointed during the period of the presidential transition. So the that's the longest period. And that statute says that the president can make the appointments. And this is also the part of the statute where the Well, let me pull it up here so we can look at the language. Right. Where there's this by operation of law, what's called the first assistant to the office, which is all in all small caps, um, can be put in by operation of law. So if the U.S. attorney dies, whoever is the first assistant to the U.S. attorney by operation of law becomes the acting U.S. attorney. And all of this happens when there's a vacancy, which is when the person dies, resigns, or is unable to perform the functions and duties of the office. Which query, does that mean if the person got fired? Right? Because it doesn't say removed or fired. It says dies, resigns, or is otherwise unable to perform the functions and duties of the office. So sometimes there's a fight over if that's what's going on. So the first option under this statute that has the longest period of time, the 210 days, is that the first assistant just steps up into the job. Then after that, there's two options for the president to appoint, which it says, notwithstanding the first option, the step up option, the president can basically appoint someone who's already Senate confirmed for a different job. Or in the alternative, it says, notwithstanding the step up, automatic step up, the president can direct an officer or an employee to perform the functions of the office if, in the year leading up to the vacancy, this person held a position for not less than 90 days, and basically they were at the same um, rate of pay for a position that would be equal or greater to a GS 15. So this third option is basically somebody who has been with the government for at least 3 months and in a high ranking position, to boil it down. Okay, then there's a bunch of, notwithstanding all of that, you can't be appointed under certain circumstances. So if they're already been nominated in the past for something else, blah, blah, blah. But we don't need to get into all of those details. So that's the first statute. Then the second statute talks about the power of the attorney general to appoint. And again, so you see this first statute, the president's doing the appointing, or it's by operation of law. In the second one, it's the attorney general, basically, who's doing the appointing. And this is under Title 28. And Section 519 gives the Attorney General the power to create for herself what are called special assistants to the Attorney General. So Pam Bondi can appoint a lawyer to be a special assistant to the Attorney General, and that section allows that person to proceed in front of grand juries. And she can do that, for whatever purposes in terms of investigating cases or prosecuting cases she wants. That's section 519. Then there's another section, 546, which is the vacancies section that applies most specifically to U.S. attorneys. And this is the section that allows for appointments for 120 days, not by the president, but by the attorney general. And that section is the one that says that the attorney general can appoint this U.S. attorney for the district if the office is vacant, except they can't appoint somebody who the Senate previously rejected. And this person serves for 120 days. And if that time expires, then you get to the very last option. Then the district court for the district can appoint the U.S. attorney. And that's what they tried to do in New Jersey in the job that's being held by Alina Hababa. Okay, so those are the rules that apply. And this is interesting in two different ways that we've been discussing. One is,
let me add one thing.
Yeah.
And I don't. This is not. I know you're dealing with the text of the statutes,
Yes. Right.
but I think on the last one, once the judges, and oftentimes the judges will just continue on with the person who was
Already
the
there.
first assistant and is already there,
Yeah.
because oftentimes the judges know that person. But I believe, and I think this has already been determined. I could be wrong, but that the person appointed by the judges can be fired by the president.
Oh, sure. The president alone has the authority to fire a U.S. attorney.
Yeah.
Even the
So
attorney general cannot do that. It must be the president.
yeah. So that last provision, which says if all else fails, the judges do it. That's not quite the end of it, because then the
No,
president
because
just
the
fires
president
that
could
person.
fire that person. Right. Although then you get back to my original question, which is, at least under the Federal Vacancies Reform Act, is a firing one of the things that causes that kind of vacancy to arise. Now,
Well, there's a
the
great, and this may have been in the briefing, but there's a great joke about that too, because Siebert in the Eastern District of Virginia claimed he wrote a letter of resignation. Trump went on social media and said he didn't resign, I fired him.
right. Right, exactly. So legally, what is that? What's the answer there? Especially because it was evident that Siebert had been advised that the president was unhappy with his services, and so Siebert followed the traditional rule that U.S. attorneys follow, which is when the president's unhappy with you, you tender your resignation because the U.S. attorney serves at the pleasure of the president, right? So is that being fired or is that resigning? So, like so many of the things that we discuss on these spaces, it would be nice if the Congress was a little more clear, or if they would act to clarify some of these problems. Like, does a firing count? Is that a vacancy as contemplated by this statute, or both of these statutes, or not? Who knows? So, the courts will have to sort that out. Okay, but what's interesting is that the we have been trying to understand with respect to these cases in Virginia, because in those cases, at least, Lindsay Halligan or Harrigan, whatever her name is, um, was probably the only lawyer in the grand jury, at least for James Comey's indictment. Right? Sounds like not she was not for Letitia James's indictment. Um, but let's say she was the only person that was interacting with the grand jury. Does that affect the validity of the indictment against Comey? I mean, I'm still not sure. But what's interesting is that there is some case law, the government cites this in its brief to California, that as long as the attorney general appointed the person to be a special assistant to the attorney general, this is under section 519. This is not the appointment of a U.S. attorney, but this is the appointment of a special assistant to the attorney general. That person would therefore be authorized to act in front of the grand jury. So if Pam Bondi did a dual appointment of whoever as the special assistant to her and also into the job of attorney general, then that would cover the two different bases. And it's my understanding that's what they've done with, I think, all four of these. They definitely did it with respect to the one in California. So that might kind of moot out the question of was Halligan properly appointed as the U.S. attorney? Because if she was a DOJ lawyer in the grand jury, then the indictment wouldn't necessarily fail. But interestingly, the government cites in its California cases a number of cases from the Seventh Circuit, which is not the circuit that California is in, but they cite these Seventh Circuit cases. Maybe they're the clearest precedents, saying that a violation of the Federal Vacancies Reform Act is not like it's a get out of jail free card for the defense, right? It might mean that the person can't have the job, but it doesn't result in voiding everything that they did prior to the judges deciding that. It doesn't invalidate the indictment per se. So, you know, the problem that the courts seem to be having with this is what I call the too cute by half problem, right? So what they've done is, like in California, The guy there was already the interim U.S. attorney. They're called interim if they've been appointed by the attorney general under the statute in Title 28. They're called the acting U.S. attorney if they go into the job under the Federal Vacancies Reform Act, which is in Title V. That's the one where, by operation of law, they step up or the president appoints them. So that's the difference between acting and interim. So in California, the guy there was already the interim. He'd been appointed by, I think, Pam Bondi into that job. And then he resigned from it. She then appointed him to be a special assistant to the attorney general under section 519 and gave him the job of the, first assistant to the U.S. attorney. And then by operation of law, he then automatically becomes the acting U.S. attorney. What do you guys think of that? So he vacates his own position by stepping out as interim. We go through these series of appointments, and then he becomes, by operation of law, the acting.
Yeah, I mean, I think that's all that's, and all of that to me is consistent. It's kind of a roundabout. It is an evasive process. They are trying to get away from the provision that says, that there's a time limit and then it's up to the judges. And this was criticized in the Third Circuit argument. I do remember reading a recap of the Third Circuit argument that, the judges seem to not be buying that.
I'll tell you what, I wouldn't buy it if I were on the Court of Appeals of the Supreme Court.
Well, I understand that. But, my point of view is at the end of the day, it's up to the Department of Justice who is the Department of Justice lawyer in the case. And as long as it's not some private citizen being, invested with authorization,
Government
law
powers.
enforcement authorization powers, if it's a Department of Justice lawyer, then what business of it is the court?
Well, in terms of
the grand jury returns the indictment.
Right.
Okay?
I'm with you there. I would not buy this argument for the appointments, but I don't think that invalidates the indictments.
But why should it invalidate
I'm
the
with
appointment?
yeah, I'm with Ship. I think it's in the law. The law is written this way. That this little circuitous, cute by half
Yeah.
procedure is written into the statute. So
Well,
why not use
I
it?
don't think so, because I think the first section that says where the first assistant steps up automatically, I think the statute assumes that that person is in that job when the vacancy occurs. And one of the things that persuades me of that is the option that the president has to appoint someone who was within the last year in that agency and had a high ranking position. So that's the first thing that persuades me, because it seems like the point is someone who has experience, either by virtue of their having already been the runner up, right? Or having served with the agency, or they've already been Senate approved. That's what we're going for with this statute. The other thing is, if you can do what they've done and run around it, then the statute just swallows itself up. You don't need this automatic step up provision at all, except to carry out this maneuver. It might as well say the AG can appoint whoever they want.
And Congress is free to close that loophole.
Well, I don't think they created a loophole, is my point.
When the shoe was on the other foot back during Joe Biden's regime, and they tried to take these small provisions and statutes and say they authorized all these COVID restrictions, which was a gross stretching of the statute, I think that's the same thing. So, what's sauce for the goose is sauce for the gander. I didn't buy it when Biden did it, and I don't buy it when the current regime tries to stretch statutes beyond their meaning so it can have its way.
Well,
I don't think this is as clear as those were.
Where I would disagree, though, is one is talking about staffing the Department of Justice and the other is not.
Yeah, but the Constitution says that in terms of that staffing, Congress has a voice. It doesn't say this is within the sole discretion of the executive.
And
Which is what you
I don't
get.
disagree. I
Yeah,
don't
yeah.
disagree. But Congress has created a set of internally inconsistent statutes. If Congress wants to straighten it out and limit the options of the president and the attorney general, they're free to do so. They just haven't yet.
I don't agree with that. I don't think they're internally inconsistent either. I think the one that says the first assistant steps up, I think the assumption, if not outright inference from the language, is that that person is already there. That person was the first assistant to the person who's
Right.
created the vacancy. Now, it doesn't literally say that. I will concede that point, but I think that's what it means.
So what
So
happens if the first assistant is gone?
then I think you don't have that option. Then the president has to pick from the somebody who's already either appointed or from an earlier someone who served previously.
Now
Or let's
here's a
well wait
complication.
let me finish with this. Let's see if the other uh, but if you go to the other statute, then it says the AG may appoint a U.S. attorney in the district in which the United States attorney is vacant, as long as they don't pick somebody who was previously rejected by the Senate. But it's just for a shorter period of time. So if the step up, if there's, to answer King's question, if there's no one in the first assistant role, then I think the president could appoint someone or the AG could appoint someone, but then the time periods are different. And that seems to be what some of the problems are in these cases, is that because the Senate is not moving very fast on the appointments, the time period becomes important. Go ahead, Chip. What were you going to say?
The overlooked factually, and I'm not exactly sure what the timing was, but before Trump put out his post saying make Lindsey Halligan the U.S. attorney, Bondi had already acted to bring in an assistant from the Western District of Virginia to
Right.
be the first assistant who then steps up. And then Halligan comes in. The first assistant who stepped up had to resign the first assistant's position to create room
Right.
for Halligan to basically.
So she could be put in as the first assistant and step up.
Right. Yeah. I think that may have been what happened. And then they took.
Yeah.
Halligan was put in as first assistant. Then the person who had been put in as acting U.S. attorney resigned as directed, or simply stepped back to being an assistant. I think, and I can't remember. It's another woman out of the Western District who doesn't have a lot of experience. Been like DOJ
Right.
for 5 years, and she's now the first assistant.
Right. And so, but at the same time, I'm pretty sure, I'm trying to find it here in the facts, that Pam Bondi appointed Halligan to also be a special assistant to her, to Pam Bondi. So I think that whatever else happens, Harrigan was in fact a U.S. prosecutor when she did both of these indictments. So I think the indictments will survive. So we're really just talking about whether or not the appointments as U.S. attorney are proper, meaning can they continue in those roles, in those jobs? King, did I see you unmute yourself? Did you want to jump in here?
No, I agree with that. I think the indictments stand, and it. I know that it rubs people the wrong way to play games with these appointment statutes. Uh, it rubs me the wrong way to have the court do it. So I'd be looking for a way to avoid that issue. Can judges be the people who appoint and set conditions and etc. for acting U.S. attorneys?
Right. I don't know why. We'd have to look at the legislative history for that statute. Why did Congress think that was a good option? Now, it's the fallback option, right? Because the president could appoint someone. the AG can appoint someone, and only if the time period runs out does the court step in.
I can almost exactly tell you why. Because when these statutes were written, nobody had the foresight to think that the district court judge positions would become so partisan over time.
Yeah. Right. It probably didn't seem all that controversial at the time to be like, well, of course the judges will pick someone who's a prominent and, well respected member of the bar to serve as the U.S. attorney. Right.
They have.
Well, I don't know if the. Do you know of any time when, other than in New Jersey, when the district court has done that?
No, because this has never been an issue before the Trump administration, and the partisanship of the district judges is
Yeah, but
essentially
I'm asking Steve if he knows in the past if that's ever been done ever, that the
there.
judges.
There was Elliot Inoki was the first assistant in the District of Hawaii. I kid you not, for 30 years. He was made the acting or interim U.S. attorney like 9 times because he was non-controversial and the judges were non-controversial. It was never an issue. It's like the U.S. attorney resigns. Okay, Elliot's going to be the boss until we get a new one.
Right. Yeah. Right. So I don't know of any incidents other than the one in New Jersey where the district court had to step into this mess and appoint someone. Perhaps that has happened in the past, but I could research it. But as long as I've been practicing law, that was the first I'd heard of it. Um, so, but it caused me to wonder, like, what is the reason that Judge Cannon in President Trump's case dismissed, when she found that Jack Smith was not properly appointed, she then dismissed the indictment. Whereas we're saying, well, even if these folks are not properly appointed as the U.S. attorney, that doesn't mean that the indictments fail. So what's the difference? But one difference I see is Judge Cannon is relying on a Supreme Court case called Lucia. And that was a case where the court said that the Securities and Exchange Commission judges were not properly appointed as a matter of constitutional law. So going back to the appointments clause, right? They needed to be appointed, I think, with the advice and consent of the Senate, they decided, and that's not how it was being done. And so in that case, the Supreme said, yeah, these appointments are bad, they're unconstitutional, and those judges were actually adjudicating the cases where people were being accused civilly of violating the securities laws, right? And so these people had cases where they'd been found liable and had to pay lots of money and so forth, by judges who were not properly appointed under the Constitution. So in that situation, the Supreme said, no, that's a do-over, right? You can't have an unconstitutional judge ruling on your case, so you get a new hearing in front of a new judge. But there are a bunch of other cases where the high court is saying the appointment is not right under a statute, and for those they don't seem to be voiding the action that the officer has taken, but they're basically saying you can't serve in this role or you can't do this going forward. So Judge Cannon for Jack Smith relied on Lucia, and that seemed, her opinion is not terribly um, fulsome on this point of what the remedy is. She basically said, well, Lucia gives us the answer, but I think that her analysis was maybe a little too thin. King, what were you going to say?
Yeah, but it's not the same issue as the current indictments. Under the current indictments, you have somebody who is under the Attorney General's umbrella. The Attorney General ultimately makes decisions about who to hire and what policy they're to follow. And the Attorney General is appointed by the President with advice and consent of the Senate. In Jack Smith's case, you don't have a statute, you had a regulation, which basically took the Attorney General out of the loop. He makes the appointment, but thereafter, all decisions, other than filing a final report or getting fired, are Jack Smith's decision. He is not a He is not inferior to the
He's
attorney general,
effectively
and
acting as the attorney general, right? Yeah.
he's his own man. But but he was never appointed by the president nor approved by the Senate.
Right. So at that point, you say, okay, if he's the equivalent of the attorney general clearly does have to be appointed by the president with the advice and consent of the Senate. I don't think anybody would debate that. So maybe that looks more like Lucia, and Judge Cannon is correct that that's the right analysis, right? But I mean, I just think it screams out, well, what are the differences? There may be principled and legal differences that would justify throwing out Jack Smith's indictment and not throwing out these indictments, but I think we should explore what those are, right? So, I mean, the other thing that occurs to me is I don't know if Smith was appointed um, under this separate section 519, whereas at least the U.S. attorney in California was. I've been looking through the pleadings trying to see, did Bondi also appoint Lindsay Halligan as a special assistant to the attorney general, which would at least make her a prosecutor in the department. And
I don't think Smith was, because you remember one of the issues that the political consideration for Smith and Merrick Garland was they wanted Smith to appear to be completely independent of the Department of Justice. Didn't want Smith to have any kind of conflict in his role because Joe Biden was running for president against Donald Trump.
Right. I agree. So maybe they didn't have that saving grace in that case, and they do here. What I'm not finding, let me look at Comey's motion, is this assertion that Halligan was appointed to this role as, special assistant to the attorney general in addition to being appointed U.S. attorney. The other thing is, Letitia James's lawyers are arguing that the time period starts to run from when Siebert filled the role. And this is a point of debate too. It's like, well, when does the 210 days start to run? Or when does the 120 days start to run? And if Siebert resigns, is that a new vacancy or is it still the same vacancy? Because the last person who held the job, who was unquestionably properly appointed, was the U.S. attorney of the Biden administration, who resigned when the administrations turned over, right? So Letitia James's lawyers are arguing that it's that person's resignation after the Trump administration comes in shortly thereafter that starts the time period running. What do you guys think of this?
That's what
I don't think
that's what I looked at, but hadn't wrapped my head around yet.
that one I can't wrap my head around. I need to study it more.
Right. And, they just, in all these pleadings, both sides, the government and the defense lawyers, they sort of just throw out these, well, this is the one that's operative, but there's not a lot of case citations explaining why that is. So, we're going to have to delve a little deeper into the case law such as it is. There's more case law on this than there is on that National Guard stuff we've been talking about, but there's not a ton. Okay, so yeah, and Comey's pleading also says that Halligan was appointed in the section not where she becomes a special assistant, but where she becomes the U.S. attorney. So let me look at the attachment. They attached her appointment papers. Let's see what it literally says. No, and so in this appointment, Pam Bondi is not invoking 519, which makes Halligan special assistant. She's only invoking 546, which makes Halligan the U.S. attorney. So that must be both pleadings do not assert that Halligan was appointed as special assistant. But they did do that in the case in California, and I wonder why they decided to do it there but not here.
Because the clock was ticking on Halligan. They had
Yeah.
3 days left until the statute of limitations expired. And apparently the circumstances seemed to be they couldn't get an existing DOJ attorney to go into the grand jury and present the case. So
Right.
just in sort of expeditious and too hurried fashion, they gave her the appointment as a U.S. attorney and said, cross the river and go do it.
Go forth and prosecute. Right. That may be their downfall. And that potentially could create the problem that she wasn't even legally a prosecutor, which seems crazy, right? But then you'd have to wonder if the indictment is good. And, if there's any law on that, I'll be amazed. But I suppose there could be. Um, since you've mentioned that they're up against the statute of limitations, I wanted to point out something. Because, King, you were talking about maybe they should supersede the indictment, at least in Comey's case, because the charge is a mess, right? You want to speak to that for a second?
Yeah, the charge is a mess because the questions and answers that form the basis
Chip,
of the
mute
charge.
yourself. Mute yourself. You're
Yeah,
making noise there.
yeah, uh, are really a mess. The charge is that Comey uh, basically lied to Congress by denying that he had.
Chip, are you cooking or eating or what? What are you doing? Go ahead, King.
Yeah, he had lied to Congress when he denied to in questioning by Congress, namely Ted Cruz, in 2020, that back in the 2016 2017 timeframe, he had leaked was he had authorized somebody connected to the FBI to leak to the press. And he said, "That's wrong. I didn't." I- Back in 2017, when he was asked that by Senator Grassley, he says, "No, I didn't." In 2020, Ted Cruz tried to ask him the same question, but gobbled it, garbled it up, and Comey said, "Well, I stand by my 2017 testimony." The way it was garbled was he meant to ask him whether he leaked. He authorized somebody connected to the FBI to leak uh, information to the press regarding Hillary Clinton or her campaign. And
Was it her
but that's not the
campaign
question.
or was it the?
Just
I thought it was
in
the.
the indictment says person number one
Right.
or person number two, and it's clear from the context that, particularly the context back in 2017, that they were talking about Hillary.
Right. But were they talking about her campaign or were they talking about the mid-year review that FBI was doing about
Yeah,
her
it
email
was it was
server?
an investigation regarding Hillary.
Right.
What and without further definition.
Right.
Uh, but in the question, Senator Cruz said called it a leaking information regarding the Clinton administration instead of the Clinton investigation. He said Clinton administration. That would
So,
be Bill Clinton.
right. He
So
either misspoke or perhaps the transcript took it down wrong because I haven't looked at the
no,
video
no.
of that. It's on the video
I
too.
watched the video.
Yeah.
I watched the video. He said administration.
Okay. So he misspoke.
He misspoke, which makes the question and answer both nonsense
And
as
prosecutors
it
love that
relates
when it's a false
a-
statements case.
as it relates to
Steve's
the
just
indictment.
shaking his head.
so uh, so Comey's got a perfect defense.
He's got a defense, right? He's got the
What I
defense of
said was true.
literally that's not what happened, right?
I wasn't even at the FBI in the Clinton
During
administration,
Bill's
and
term,
there was
right? Yeah, right. Yeah,
so they need to fix it. Uh,
right. And that's where we're going with this. They need to fix this because Comey in his motion to dismiss the case against him for vindictive and selective prosecution, he has this section in there that says basically the indictment's not worth the paper it's written on, right? He says it's fatally flawed. And this is what he's saying is the fatal flaw is that the count is a fucking mess. He doesn't say it that way. That's how I'm saying it. But that's his point. Now, he does not ask the judge to dismiss the indictment on that basis because he cannot. There's no pretrial mechanism for saying they could never prove this because it's a stinking pile of garbage, right? He's got to wait until they put that stinking pile of garbage on as evidence in their case and then they lose. But that's where that count is going more than likely, right?
no question. No question. Not to mention the fact that he never really answered Cruz's
Right.
question.
No, he kept kind
He
of
just said
evading it. Yeah.
he said, I'll stand by whatever I said before,
Right. Right.
which was a different question.
Right. Lindsay was asking him a different question than what Cruz seems to be asking.
No,
Right.
he says I'll stand by my testimony from 4 years ago, 2017, or 3 years
Right.
ago.
Right.
Uh,
When Graham was asking him
but
questions.
I think it was Graham or
Oh,
Senator
no, you're right. It
Grassley.
was Grassley. I
Grassley,
misspoke. It was Grassley.
and
Yeah.
but that's a different question. Grassley was talking about the investigation of Hillary Clinton. Cruz is talking about the Clinton administration. So,
Right.
how do you put those all together? And plus the answer, uh, I stand by my testimony.
Well, the other thing
What does
is,
it mean? What does
what does
that
that
mean?
mean exactly? Which part? The part that Cruz was summarizing for you?
Yeah,
Okay.
yeah.
Well, if you look at what Cruz was summarizing the discussion of whether Comey had authorized McCabe to leak. But the
Mm.
indictment is clearly set up not to be talking about the leak by McCabe, but the leak by Professor Richmond. So Comey, if his lawyers are going to make hay out of that too, and say, well, Senator Cruz was asking us about someone other than the guy they put on as a witness, right? So how is Comey's answer false
It There is no way he gets convicted under this indictment.
on that charge? I agree with you.
On
I
that,
think it's virtually impossible for them to get a conviction on that.
now they still have the obstruction count, which is separate.
Yeah, separate, except it says it's based on false statements to the Congress. This same statement,
It doesn't say.
right? It doesn't. So then they're going to have to say what those are, maybe not to the public, but they're going to have to tell his defense lawyers exactly what statements they're claiming are false for purposes of the obstruction. Siebert filled the role, kicking pile of garbage on as evidence in their case, and then they lose. But that's where that count is going, more than likely, right?
No question. No question. Not to mention the fact that he never really answered Cruz's
Right.
question.
No, he kept kind
He
of
just said
evading it. Yeah.
he said, I'll stand by whatever I said before,
Right. Right.
which was a different question.
Right. Lindsay was asking him a different question than what Cruz seems to be asking.
No,
Right.
he says I'll stand by my testimony from 4 years ago, 2017, or 3 years
Right.
ago.
Right.
Uh,
When Graham was asking him
but
questions.
I think it was Graham or
Oh
Senator
no, you're right. It
Grassley.
was Grassley. I
Grassley,
misspoke. It was Grassley.
and
Yeah.
but that's a different question. Grassley was talking about the investigation of Hillary Clinton. Cruz is talking about the Clinton administration. So,
Right.
how do you put those all together? And plus the answer, uh, I stand by my testimony.
Well, the other thing
What does
is,
it mean? What does
what does
that
that
mean?
mean exactly? Which part? The part that Cruz was summarizing for you?
Yeah,
Okay.
yeah.
Well, if you look at what Cruz was summarizing the discussion of whether Comey had authorized McCabe to leak. But the
Mm.
indictment is clearly set up not to be talking about the leak by McCabe, but the leak by Professor Richmond. So Comey, if his lawyers are going to make hay out of that too, and say, well, Senator Cruz was asking us about someone other than the guy they put on as a witness, right? So how is Comey's answer false
It There is no way he gets convicted under this
on
indictment.
that charge? I agree with you.
On
I
that,
think it's virtually impossible for them to get a conviction on that.
now they still have the obstruction count, which is separate.
Yeah, separate, except it says it's based on false statements to the Congress. This same statement,
It doesn't say.
right? It doesn't. So then they're going to have to say what those are, maybe not to the public, but they're going to have to tell his defense lawyers exactly what statements they're claiming are false for purposes of the obstruction. If it's this same one, then they're out of luck on this too. So you had raised with me the question of, well, could they supersede the indictment, right? And charge him with something else other than this pile of crap that they've charged him with. Um, I wanted people to know the law on this is interesting, but it can be technical for statute of limitations purposes when you supersede the indictment. So, in general, if the prosecutors supersede the indictment and they don't substantially broaden, change the charge, and they don't bring a new charge, then the superseding indictment, even if it's after the statute of limitations has technically run out, then it just relates back to the day that they filed. Like it just substitutes for the indictment that they're superseding. But that's only if it isn't a substantial change and it doesn't add new charges. If you add new charges, then those new charges have to be brought within the statute of limitations. Or if you substantially change the charge you've got, it has to be brought within the statute of limitations. So they can't do that because the statute of limitations is blown by now. But an interesting wrinkle also is in the criminal court, when the prosecutors file the indictment, it stops the running of the statute of limitations. And the statute of limitations, whatever days are left, just kind of sit there behind the scenes. And if the indictment is dismissed, it starts the statute running again. So I think when they indicted Comey, they had 3, 4, maybe 5 days left. And they can still use those days against him to bring a charge against him. But to do that, they would have to dismiss the indictment first to get the days running again. You follow what I'm saying?
I do.
Yeah.
I'm not sure everybody else
Right.
does, but it's because it's it's
Yep.
tricky. But the fundamental problem here is they're trying to use testimony he gave in 2020, and the questions are mixed up. His answers are. I mean, he dodged. He
Mm-hmm.
intentionally dodged. He saw what they were trying to do. He's trying to make me lie a second time. I
Right.
lied back in 2017, and they're trying to make me repeat the same lie. And he refused to do it. He said, "Go look at what I said back then." That's
Right.
basically his answer. Which is that a lie?
Right. Can that even be a lie?
Mm.
Right.
Yeah. So
Sitting there that day. Go back and look at what I stand by what I said before. That
yeah,
how can that be false or true?
Exactly. So it it's a it makes a tough uh, case, which fundamentally a tough case, which are all which which you have in every false statement case,
Yeah,
and you make it 10 times worse.
right. What's interesting is we identified this the first day we talked about it, that this count is a mess, and the more we've looked at it, the messier it looks, right? And his lawyers are all over this. But they're definitely going to make all the hay they can out of it. So I really think, like you, that they're losing this case against James Comey unless they can get a different charge on file instead. And the only way I think they can do that is to go through that transcript, see if there's something cleaner that they can use. They could try to recharge the one that the grand jury wouldn't return on. They're not prohibited from doing that. They can get a different grand jury to look at those facts again. And that has some problems with it too, but it's cleaner than this, even with the problems that it has. And maybe there's other things in those transcripts that they could use for a false statement. If I were them, I would go through that whole analysis, have somebody who's got more experience as a prosecutor than Lindsay Halligan has, and see, is there a better charge we can use here? And then get it ready to go, dismiss the case, get the judge to dismiss it, and then boom, go to the grand jury the next day and get a new indictment. And if they do that, they might be able to salvage a case against him. But if they don't do that, I don't think this case against Comey ends up in a conviction.
My guess is they're going to try to use the charge that the grand jury didn't buy, the one based on his statement. I don't remember. What was the question?
Lindsey Graham was asking him about, did he have knowledge that, wasn't it that Hillary's campaign was behind the uh, Steele dossier? Wasn't that what it was about?
That was it, and he professed not to remember.
Right. Or not to remember that
Mm,
he'd been told that
cor-
by Brennan, I
Correct.
think.
Right.
Yeah.
But that was a false statement charge. Uh, they did indict him for trying to obstruct the Congress by making false statements. It's theoretically possible they would use that false statement that I don't remember as part of the obstruction charge. What do you think of that?
Well, I agree that technically they could try to shoehorn that into the obstruction as one of the false statements. It does say statements plural. They'll have to identify what the statements are, but they don't have to necessarily do that in the indictment. So yeah, they could technically do that. Although when I talked to Steve about this, and he's like, "Is this the one where he said he didn't remember?" And I say, "Yeah," and then he just rolls his eyes because he
So,
thinks, false statements case based on a remembrance is probably dead in the water too.
yes, I agree. And but if they don't do that, I don't think they. I think the statute of limitations is run as to any false statement charge.
Right, except they've got this 3 or 4 days left, but they'd have to dismiss the current indictment.
Uh, but but the you're talking about a new charge, a new and different charge.
Right. So they can't supersede with a new charge.
Right.
But that's because the indictment's on file, right? If you dismiss that indictment and there's no charges pending against him, then you have whatever days you had left of your statute of limitations when you got the first indictment. Do you see what I'm saying? They didn't file the indictment on the last day.
Yeah. I thought it was closer to.
Oh, it is.
I thought.
It's within a week. It's 5 days
Yeah.
or less. Yeah.
Okay.
So you'd have a few days. Once the judge dismissed the indictment, you'd have a few days to get a new indictment on a different charge. That could technically be done. The courts, I think, would uphold that. But if I were them, I'd go through that transcript with a fine tooth comb and try to find something better than these two ridiculous statements.
Either that or find a continuing conspiracy that
Right, some
Coleman
other whole different
joined.
charge, but that's going to be
Right.
probably on a different statute of limitations time frame anyway, right? So if you're trying to dig up a false statement based on that 2020 testimony, you got to have something that's in there. So, so anyway, that's I think the unfortunate reality of this Comey case is that it's Abby Lowell's going to come out on top with that. Not Abby. He's got Letitia Patrick Fitzgerald. Now, interestingly, though, whether he's going to stick around on the case or not is also an issue because the government is going to try to get him booted off that case. I'm pretty sure. They haven't technically asked for that yet, but they filed some notices with the court about privilege review and so forth, and they went out of their way to educate the judge about how Fitzgerald was involved with the transmission of the classified information to this professor. So I think that they're going to be filing a motion to disqualify Fitzgerald.
I expect to see that too.
Yeah. Okay, so I think that's all for us for tonight. Just to let the folks know, we're going to be doing King and I part 8 of our JFK series on Wednesday, right? Wednesday?
Wednesday.
Wednesday. What
Yes.
time?
I think you said 2:30 Eastern.
2:30 Eastern.
Right.
Yep. Okay, fantastic. All right, my friend. Well, I look forward to talking to you then, and
Okay.
I will say good night.
Good night, all.